So 152 members of Congress have gotten together and have filed a brief to the Supreme Court telling them that they should uphold New York's concealed carry laws. So let's talk about this. But real quick before we jump into this video, if you think the Supreme Court should strike down concealed carry restrictions, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfec.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, 152 members of Congress led by Chuck Schumer have gotten together and chimed in to tell the Supreme Court that it should uphold New York's restrictions on concealed carry licenses, and this is in the case New York State Rifle and Pistol Association v. Bruen/Corlett, which the Supreme Court will be hearing oral arguments on November 3rd. So some quick background on this case and why it's so important for our Second Amendment rights. This case is a challenge to the state of New York's concealed carry permit requirements. The state requires a person to provide proper cause to be issued a permit to carry concealed. Proper cause exists if the applicant has an actual and articulable rather than merely speculative need for self-defense. The state does not consider self-defense a proper cause, and therefore on that justification alone, people have their permits denied. Proper cause can also exist in the state of New York if the applicant intends to use the handgun for things like target practice and hunting. However, licensing officers can and often do restrict the carry license to those purposes that are used as a justification for why individuals should have those permits. And that's exactly what happened for the plaintiffs in this case. They applied for a permit, but they had those permits restricted to just hunting and target shooting when they really wanted to be able to carry out in public for self-defense. Now, the question presented in this case before the Supreme Court is whether the state of New York's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. So the whole question in this case is whether the state of New York violated the Second Amendment when they denied people's permits when those people only put forward self-defense as a justification of why they should be able to carry concealed. In response to this case going up to the Supreme Court and the Supreme Court holding oral arguments on this case on November 3rd, all of these congressional members got together and have filed an amicus brief to the Supreme Court, essentially arguing that they should uphold what the state of New York is doing here in this case. In this brief, the congressional members make three main arguments. Those arguments are first, that there is a long tradition of legislators regulating public carry. Second, that public carry restrictions are consistent with the legislative power to regulate lethal force in public. And finally, in number three, that unrestricted firearms in public can harm the exercise of other constitutional rights like freedom of speech and the freedom to engage in free elections. In this first argument section, the congressional members state that the Anglo-American tradition of legislators regulating public carry stretches back centuries and continues to this day. They go on to state that public carry laws requiring a showing of proper cause, like New York's concealed carry licensing scheme, have been in place since the early 1800s. They argue in this section that English law and early American law supports the ability of New York to restrict concealed carry in public. However, while twisting early American history, these 152 congressional members completely missed the mark. This New York scheme is an outright ban on people carrying firearms concealed in public for self-defense. And that aspect of for self-defense is important and is the whole question in this case. In rare instances, some areas historically restricted wearing unusual or otherwise unlawful weapons, or they restricted carrying arms in a way that could cause fear or terror to citizens. But none of those historical analogs or laws support an outright ban on carrying firearms for self-defense out in public like what the state of New York does. In their second argument section, these 152 congressional members state that public carry regulations are firmly rooted in both this court's Second Amendment jurisprudence and the legislator's traditional role to regulate the use of lethal force in public. They go on to state in Heller, this court explained that the core protection of the Second Amendment is the right of law-abiding, responsible citizens to use arms in defense of hearth and home. Outside the home, the carrying and use of arms has been more circumscribed to protect other citizens' ability to safely enjoy public spaces. Now, this statement goes to the fact that these individuals believe that the Second Amendment protects primarily and only your right to self-defense within the home. But the moment you step outside your front door, your Second Amendment rights vanish and the government has the power to limit your access to firearms. Their third main argument, and the one I want to spend more time on because it's kind of hilarious, is the fact that they argue that public carry regulations are consistent with the Constitution. The practice of carrying guns in public without meaningful oversight threatens participation in civic life, undermining our democracy and other constitutional rights. As the last year has shown, they argue, the unrestricted public carry of firearms can and does interfere with the proper functioning of democracy. It can inhibit First Amendment expression and the electoral process, and directly disrupt the workings of government. Our democracy cannot tolerate these harms, and the Second Amendment does not compel us to. So that is what they are arguing in a main section of their argument, is that the Second Amendment on its own and your ability to carry firearms out in public for your self-defense effectively hinders other constitutional rights like the freedom of speech and your freedom to actually engage in fair elections. So this is something I want to bring to your guys' attention in this video and this type of argument, because this is something that goes against something that us in the 2A community hear a lot, which is that our Second Amendment protects your First Amendment right. Here, however, these 152 members of Congress believe that your Second Amendment right is a hindrance to all other rights. Later in the brief, they state that civilians carrying guns into communal spaces can chill or shut down the rightful expression of free speech and political protest that the First Amendment is intended to protect. Requiring licenses to carry concealed guns in public and imposing reasonable conditions on licensure is an important and effective tool for preventing these civic harms. They then go on to give examples of various peaceful protests that were hindered last year because of armed citizens. But as we all know, most of those protests that they claim are peaceful, police and governments in those areas just simply let protesters burn and loot towns, and it was ultimately left up to those lawful civilians in the area to protect their homes and businesses. But this brief says that those people protecting their homes and businesses are the problem, and that they are the ones that are chilling free speech and that they are chilling protest. So in classic fashion, they are trying to shift the blame from those so-called peaceful protests to those individuals who are just simply trying to protect themselves from those protests. Finally, in this brief, they argue that firearms in public impact elections. Now, I'm not going to go in depth on the absolute garbage arguments made in this section of their brief, but essentially they state that firearms are to blame for various issues last year during the elections, and they're also trying to blame firearms on the subsequent protests and issues that happened after the election. So in summary, these 152 members of Congress want the Supreme Court to uphold New York's licensing scheme, and they are saying if the court doesn't, firearms in public will destroy our First Amendment rights, and as well they will destroy our elections. So let me know what you guys think about these arguments down in the comment section. And also, if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. And if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos, in this type of 2A news, and then it helps push it to more people. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are absolutely destroying the algorithm. You are helping these videos to reach more and more people and helping this channel to grow. So thank you so much for doing that. And if you don't have a comment in mind, just comment down below that you're commenting to fuel the algorithm, and I really appreciate that. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.